the marriage equality cases, which have to rank with Brown versus, well, let's have a round of applause. I think, Justice Kagan, you actually asked the question in the Windsor oral argument involving the constitutionality of the Defense of Marriage Act that resolved the case. And when you asked if there was actually a gasp in the courtroom, you said that the lawyer for defending the Defense of Marriage Act said there were plenty of rational reasons for Congress to pass this act. And you said, I want to read from the House report. Didn't the House say, when it passed this law, the goal of the Defense of Marriage Act is to express moral disapproval of homosexuality? And there was a gasp in the courtroom when you said that. And there wasn't really a very good answer to that question. And then in Justice Kennedy's majority opinion striking down the Defense of Marriage Act, he quoted from that very same language that you had mentioned in the courtroom, and he noted that the court has previously said that moral disapproval of any group is a form of animus that is not an acceptable constitutional reason under any form of constitutional scrutiny, and that was why the Defense of Marriage Act had to fall.
I'm sorry,
the stage is yours.
No, it was a kind of obvious question, and it was an obvious question because the court has set this down as a principle of the Equal Protection Clause. Most recently, in a case called Lawrence, which Justice Kennedy wrote, but the principle appears in other parts of the court's jurisprudence as well, and it's basically it says that the Congress or a state legislature can't pass, class legislation that's based simply on moral disapproval of a group, or animus, or fear, or disfavor of a group, unless it has some basis in actual harm, unless there's some reason to think that the public interest will be furthered by that kind of legislation. So if all you have is moral disapproval and is a sense that we just don't like these people and we don't want them to share in the full benefits of citizenship, that's a violation of the Equal Protection Clause. And Justice Kennedy was really stated that very forcefully in his Lawrence opinion 10 or 15 years ago. And that's what he came back to in this opinion. And you can say on the other side, well, what's wrong with moral disapproval as a basis for law? But I think what the court has decided is that it's not sufficient. And one of the things that's interesting about this set of opinions is that even the principal dissent in this case really stays away from that and does not try to re-argue the proposition that simple moral disapproval is sufficient for a law to stand, but instead tries to argue that there were other interests underlying the law, interests in effective administration of federal statutes, interests in avoiding choice of law issues. And what the question was meant to do was to say, well, look, here we have some evidence here of what actually was animating the Congress that passed this law, and what evidence do we have that Congress was being motivated by these more neutral considerations that just have to do with efficient administration of the laws. That's what the question was meant to do, and I think, what Justice Kennedy's opinion in Windsor suggested was, in this case, there's every reason to think it was animated by moral disapproval.